Dear colleagues, ladies and gentlemen, Hungary currently holds the rotating presidency of the Council of the European Union. Preparations for this challenging task have started years ago with a view to identify priority areas. From the very beginning, we believed that a systematic and scientific overview and analysis of the most pressing problems of the European Union are indispensable for setting meaningful priorities. We also believed that even though presidencies are honest brokers within the Council and are not supposed to represent a political point of view or particular and regional interests, we can bring the added value of a certain central European approach and background that enriches the European Union. These considerations are perfectly manifested in the international research project launched in 2023 by the Central European Academy, focusing on the priorities of the Hungarian presidency, including demographic challenges, migration, security and defense policy, economic governance and rule of law. I thank the Central European Academy and its professors network, and in particular Professor Ede Szilágyi, for answering the call and contributing to a better understanding of our common challenges from a Central European point of view, as well as formulating ideas how to tackle them together. It has been a huge task. As a result, we now have 5 volumes containing over 120 studies from almost 100 contributors representing Central Europe. Even though the ideas and positions expressed in the studies are not the official position of the presidency, I believe it is hugely important that they are circulated all over Europe and become part of the political and professional discourse. The presidency will facilitate this process by circulating the outcome of the research projects among decision makers in printed and electronic format. I had the honor of coordinating one of the research projects in this exercise, devoted to the phenomenon of the supranationalization of the concept of rule of law. This tendency is embedded in the process of creating constitutional federalism in Europe with the instruments of soft and hard law. The process necessarily entails certain limitations to national sovereignty, and this continuation could reasonably be expected in the future, as the interpretation of the rule of law is increasingly being transferred to the supranational level. Parallel to this process, the question of how such an interpretation could be enforced and sanctioned in different member states is being raised, with special regard to those where the interpretation and practice of the rule of law do not correspond with the supranational understanding. The project addresses the process of the supranationalization of the rule of law in different institutions from the perspective of Central European countries. It presents and analyzes the experiences and approaches of Croatia, the Czech Republic, Hungary, Poland, Romania, Serbia, Slovakia and Slovenia in relation to the different processes within supranational institutions. Particular attention is given to the EU and the issues of EU competences in the context of national sovereignty and the hierarchy of the institutions controlling the rule of law. Therefore, the supranationalization of the rule of law is examined individually in different procedures and mechanisms, such as the rule of law review cycle, the EU Justice Scoreboard, the Article 7 procedure, the European semester, the conditionality mechanism, and the cooperation and verification mechanism. The values enshrined in Article 2 TEU were not developed during the European integration process. They are deeply rooted in the constitutional traditions of the member states. The rule of law as a principle, or since the adoption of the Lisbon Treaty as a value, appeared also on the level of the EU. This opened the question whether its interpretation should be based on the constitutional interpretation of the member states or can be developed independently from them. And consequently, issues of enforcement also arise, including judicial control. On a more theoretical level, we are facing 3 dilemmas. The first set of dilemmas relates to the objective of changing nature of the EU from a body of rules into a body of values. Supposedly, it has to do something with the fact that the EU is not only a community of laws, but also a community of values. I strongly believe the European Union to be a community of values, not only and not primarily because the text of the treaties is open to such interpretation, but because it is a fact. But I also strongly believe that the fact that the EU is a community of values does not mean that EU law must be transformed into a body of values. And consequently, I also strongly believe that EU institutions, including the Court of Justice, are not the designated venues for value disputes, and this argument applies a fortiori to the Commission and the Council. The second set of dilemmas is related to the application of values by EU institutions. Application of values is a fundamentally different exercise compared to the application of rules. I am afraid we have not yet grasped the full complexity and sensitivity of this difference. And here my primary concern is not methodological, even though I think there is a lot of room for improvement in the application of the comparative method by the EU institutions. My concerns run deeper and touch the core principle of equality before the law for both individuals and member states. The exposition of this problem would go well beyond my time limit, but I managed to come up with a good phrase that sums up my point. Equal application of rules require the equal treatment of each case, but equal application of values require the equal treatment of all cases. And the difference between each case and all cases is the key here, especially since the EU now has new procedures at its disposal that center on values and have far-reaching political and financial consequences. I believe that we have a very good understanding of rule of law to engage in a dialogue about it, but we are extremely far from a standard that would allow imposition of punitive measures in case of a breach. Maybe we never get there, but even if we do, what does the EU have to do with it? And here my final set of dilemmas relates to the competences of the EU. Of course, member states and individuals are happy to see EU institutions enforce values that they share and agree with against certain member states and individuals in certain opportune cases. And in the current political context, the case of Hungary is always opportune. But I am not sure that member states and individuals would consider this as a general consent to the monopoly of definition, interpretation and enforcement of European values by EU institutions. And this dilemma again goes even deeper, because an ever closer union of rules is fundamentally different from an ever closer union of values. There's a quantum leap here that needs clear political authorization on one hand and the complete restructuring of the system of EU and member state competencies on the other hand. In this context, the focus should no longer be on the enforcement of EU competencies, but on the protection of member state competencies. So, supranationalization of the rule of law that is embedded in the constitutional federalization of the EU is ongoing, but curiously it is a one-sided process because it does not include EU institutions. I think Article 2 TEU is quite clear on this by stating that the Union is founded on certain values, including rule of law, so somehow adherence by the EU institution to these values must be expected, monitored and enforced. In the Hungarian presidency's program, we pointed out that respecting and upholding the values enshrined in Article 2 of the Treaty on European Union is the responsibility of all actors of the Union, member states as well as EU institutions, bodies, offices and agencies. The EU has a number of mechanisms for monitoring member states, in particular with regard to their respect for the rule of law. However, the current EU toolbox does not allow for monitoring whether the rule of law is respected within the institutional system of the EU. One of the aims of our presidency was to examine how to fill these gaps. The Hungarian presidency organized an exchange of views at the informal meeting of the Ministers of European Union Affairs in Budapest on the 2nd and 3rd of September on how the EU institutions could improve the quality of EU legislation by better lawmaking in a way that both strengthens the rule of law and enhances the competitiveness of the Union. Member states engaged in very constructive exchange of views, focusing on the issues of impact assessment and stakeholder consultations, which obviously has implication for all policy areas. The delegations agreed that these objectives would be served both by taking better account of member state specificities and by better mapping and reflecting the views of relevant economic actors in EU legislation. The debate can be an important driver for further improving the EU better lawmaking toolbox during the envisaged revision of the interinstitutional agreement on better lawmaking. It has been a step forward, but I admit that it is very far from the objective of applying, monitoring and enforcing rule of law standards vis-à-vis EU institutions in a systematic way. But how this rule of law review process should look like when it comes to EU institutions? I suggest to focus on the functioning of the EU institutions and simply apply the same procedural rule of law principles that EU institutions apply when evaluating member state institutions. I'll give you two very simple examples. First, the case allocation system in courts. Independence of courts of justice is undisputedly a prerequisite of rule of law. The Commission's rule of law report suggests that the lack of a proper and objective case allocation system questions the right to a lawful judge and thus the access to independent courts. The Commission also contends that there are clear European standards in this regard that member states must follow. I fail to see why the lack of case allocation system based on objective criteria in the Court of Justice of the European Union is not an issue when it comes to the rule of law in the EU. Second, asset declarations and their verification in EU institutions, including the Commission and the European Parliament. Asset declarations and the transparency and verification are clearly a rule of law issue when it comes to member states, and the Commission again seems to be in possession of some kind of European standards in this regard that it wants to enforce vis-à-vis member states. Again, I fail to see why lack of compliance with these standards at EU institutions is not a rule of law related issue that merits our attention. I singled out these two examples to drive home a point. Questioning the substance of decisions by EU institutions on value-based considerations and then try to portray this process as rule of law review is wrong. What we should focus on is to make sure that the EU activities of institutions are transparent and comply with elementary procedural rule of law requirements. We must make sure that the court is legally formed, even if it's the Court of Justice of the EU. We must make sure that there is no conflict of interest in the legislative process, or at least it is disclosed, even if it concerns the Commission or the European Parliament. Then we can start discussing whether a court decision or the content of EU legislation complies with our value judgment. But we must be aware that these two issues, namely compliance with procedural rule of law standards and value content, are very different types of concerns. I am aware that I enter uncharted territory, but this is the consequence of the subject matter itself. Rule of law in the EU is not a stabilized area of research, and through discovering this field we keep bumping into the fundamental questions related to the very nature of the European Union and the integration process. I encourage all of us to continue this quest even outside our comfort zone. It is worth it.